And we're on record. This is Timothy White versus Clark County. Can we have an introduction of parties and counsel then, please?
Your Honor, my name is Jane Beto. I am here for Clark County.
I'm sorry, what's the name?
Jane Beto.
How do you spell the last name?
It's V as in violin, E-T-T-O.
And
Your
counsel?
Honor, I'm Mark Zemmel here for Timothy White.
Mark, what was the last name?
Zemmel, Z as in zebra, E-M-E-L.
And you're Mr. White?
Yes, black and
Okay.
white.
Very good. Good afternoon. So you may have heard I'm sort of the hot potato ended up in my lap, I guess, on fairly short notice. So honestly, I've reviewed some materials, but I'm fairly fresh to the case and fairly fresh to this area of law. So if the party, I'm not going to fault the parties for taking a wide turn in terms of...
Well, Your Honor, as I said, I'm Mark Zemmel, and I'm here with Timothy White, who traveled here from San Juan Island to be here today. And thank you again for taking this matter on such short notice. Mr. White seeks to have public records that he requested under the Public Records Act immediately produced. We believe this is a simple case where Mr. White made a request for specific public records under the Public Records Act, and Clark County unlawfully withheld those documents. The Public Records Act is a very powerful statute. It ensures that agencies are accountable to the people and retains the sovereignty to the people by holding by maintaining control over the instruments that the agencies are mandated to produce records upon request under the Act, unless there are specific exemptions that apply to the records requested, and that is only in very limited circumstances. Exemptions are only found in statutes themselves or in case law. They're not found in administrative practices, in the administrative code, or any general workings of agencies. And even if an exemption applies to information contained within a public record, the Act requires that that information is redacted and then the remaining documents. We actually have the benefit of thorough and unambiguous Supreme Court precedent that outlines agencies' duties under the Act. It says that that the Act must be liberally construed and its exemptions narrowly construed to promote the Act's public policy of openness and transparency. When there's any doubt about the application of the Public Records Act, the court must find in favor of public access. The Supreme Court has explicitly said that the purpose of open government is paramount in the Public Records Act, and the court cannot imply exemptions. They must be explicitly identified in statute or in case law. There are also no general exemptions contained within the Act. They need to be explicit and specific. And finally, even if an exemption is on point, a court may disregard it if the exemption is unnecessary to protect an individual's right of privacy or any vital governmental function, and that's contained within the Act itself. The Act is intended to be sweeping and powerful to ensure agency accountability and transparency. Indeed, the Public Records Act is as strong as it could be. So we believe the court should follow the lead of Colorado and Vermont, where completely analogous facts were at issue, where they ordered production of ballot images, digital images. Those are the records at issue here. And to walk you through the process here, in Washington and in Clark County, ballots are submitted by mail. Voters mark their choices on a paper ballot, then mail it in. The ballot is immediately scanned, creating a digital image, and that digital image is stored on a computer with the county, and the paper ballot is placed in a secure location until they're destroyed. So there are several overarching reasons the documents should be produced here. First, it is undisputed that the files are public records subject to the Public Records Act. Second, there are no exemptions for the records in the Public Records Act itself. That's also undisputed. And there are no exemptions for the records in the Constitution or statutes, despite the arguments made in the county's briefs. The Constitution guarantees secrecy in voting, but does not impose a broad veil of secrecy over the election process. Elections are public. The counting centers are open to public observation. And the only prohibitions that the secrecy in voting provision imposes is that the ballot must be anonymous. In fact, the county is prohibited by law from creating or maintaining any record which would permit voter identification, and that's contained at RCW 29A-08161. So there really is no issue with ballot secrecy here.
What's the statute again?
29A-08161. It reads, no record may be created or maintained by a state or local governmental agency that identifies a voter with the information marked on the voter's ballot, including the choice that a voter makes. Indeed, the counties have provided no evidence that identifiable ballots are included in the request at all. And even if identifying information would be included in production, that information could be redacted in the remaining record. Now, the county relies heavily on the ballot security provisions of Washington's election laws, which require that ballots be stored in secure locations, but that is not an exemption under the Act. An exemption cannot be implied, and those statutes are intended to maintain the security of a ballot against fraud. It is not some veil of secrecy over public access. Indeed, the county also makes the argument that the images don't exist and that it would require creating a new record, which is not required. But the county confuses different formats from new records. The counties are obligated to decrypt encrypted records so they are readable by the public under the Act. And I'd refer the court to WAC 434-662-070. Quote, if encryption is employed on public records, the agency must maintain the means to decrypt the record for the life. The county itself also references ballot images repeatedly and confirms they can be, quote, printed out. And I refer you to the Declaration of Garber at page 7, line 2. I mean, it's pretty clear that what they are printing is an image that shows up on their computer screen, which is a record that exists and is subject to the Public Records Act. Also, in the Garber Declaration at page 7, line 21 to 22, quote, the scanned images are converted to a proprietary format that only Ballot Now can read and process. Now that quote shows that scanned images do exist. They are records subject to the Public Records Act. And the fact that they're converted to a proprietary format also means nothing. Again, I refer you to RCW 29A-36-111, subsection 2, quote, an election official may not enter into or extend any contract with a vendor if such contract may allow the vendor to acquire an ownership interest in any data pertaining to any ballot. Claiming that a program that allows the agency to read an image is not an exemption under the Act. They need to convert it to a format that is readable by the public and produce it under the Act. Also in Clark County's email from November 12, 2013, which is Exhibit 3 to Mr. White's first declaration, they say, quote, please be assured that all ballot image files remain intact throughout the tabulation process. Again, pretty clear that these images exist, are public records, and need to be. And finally, even if the courts find an exemption applicable, the court should order production of the records under RCW 42-56-210, subsection 2, because there is no risk to anyone's privacy rights or any vital governmental function. Now, the Supreme Court has said, quote, the trial court must find that a specific exemption applies and that disclosure would not be in the public interest and would substantially and irreparably damage a person or a vital government interest, end quote. And that's from Soder versus Spokane School District number 81. There are no secrecy concerns here. Ballots are anonymous. They're mandated by the Constitution to be anonymous. The statutes explicitly prohibit the county from maintaining or creating any record that would permit identification of the way an individual voted. So there are no secrecy concerns here. And there are no vital governmental function concerns either. There's no risk of fraud or tampering. As I mentioned, there's no need to access the paper ballots themselves, which remain intact and remain the official ballot and official record of the election. And the election has already been certified. This election is over. There's no risk at all. On the contrary, it is actually in the public interest to make these records public. It promotes citizen involvement and confidence in the election process, which is the fundamental instrument of our democracy. It helps safeguards against errors, fraud, and abuse with additional public oversight. And ballots have always been processed, canvassed, and counted in public. They are still counting centers are still public to this day, and in the past they were even, the whole process was even more in the public domain when it was not decentralized and when counting and verification occurred at local precinct level with public observation. And I'd also just like to add that since the advent of mail-in voting, elections span over a month. Ballots trickle in order for the public to actually be able to exercise their rights to verify and oversee the election process. They would have to be sitting in the counting office for 8 hours a day, every day, for several weeks, if not months, before they could actually have a meaningful participation in the process. This, by making these documents and records public, it merely provides a more efficient way for the public to be involved and to verify. So I just want to highlight that Clark County's arguments really fail on multiple levels, and they need to prove their arguments at every step, while Mr. White only needs to show that one is true. The records would need to be ballots in order for their claimed exemptions to even apply, which they are not, as the definition of ballot is explicit about. The security provisions would need to be Public Records Act exemptions, which they're not. There are security provisions for all public records, and the Public Records Act mandates production of public records upon request. The county would need to be unable to redact exempt information, which of course they can. And withholding the public records would need to be necessary to protect against substantial and irreparable damage to a person or a vital governmental interest, which, as I mentioned, are not necessary at all. Now, Vermont and Colorado have made these records publicly available, and the court should follow their lead. The sky is not falling in those states. Those records are public. They're even posted on websites for all to see. There is no violation of the secrecy of a ballot, and there have been no problems. The sky is not falling, and Washington, with its strongly worded mandate in the Public Records Act, should follow the lead of Vermont and Colorado. Thank you.
Thank you. Ms. Veto?
Thank you, Your Honor. May I approach? I'm getting a little bit scratchy, and you may not hear me. Thank you. Your Honor, I will try to keep this short so that I'm sure you have a lot of follow-up questions for me. But I would like to outline the county's position very briefly, if I may. The first thing I'd like to note is that plaintiff's counsel and I do agree on one thing, and that is that the issue is pretty simple here. The state of Washington has laws for accessing voted ballots, but the Public Records Act is not the way for the plaintiff to do that. Washington state laws are centered around the concern for the integrity of the election process. And Washington has all sorts of policies and procedures that are outlined in our brief for the secrecy of the ballot to be maintained. The proper way for the plaintiff to access these records, therefore, the ballot is taken out of the envelope, the signature is verified, it is immediately scanned into not a computer, into a voting machine, and then the original ballot is locked and sealed away, and that voting machine, it codes that ballot. And as she says in her declaration, the ballot is not an individual image at that point. It is a series of binary codes that we can't read. And there's a couple reasons for that. One, because we contract with the company, and that's their business, and they want to keep that proprietary information. Two, going back to the election statute, the election staff cannot go in and see this ballot and see who did what, because every ballot has a unique identifier. So this maintains the secrecy. Even if the court were to find that despite this law, that these records were releasable, under other Washington law, the county is not required to create a record from existing data. And I know that you were deluged today with a lot of briefing, but I would, if you haven't, I would encourage you to read our declaration of Kathy Garber, our election supervisor, because she is much more articulate than I am in this declaration, and she really sets out what happens with these ballots when they're scanned, that they're not images when they're in this machine, and it's not a computer, it's a machine, and that in order for her staff to go in and get an image, they actually have to pull up data, which is illegal with their contract with this vendor, and also illegal under the statute, under the election statute. They would have to pull up this data, they would have to input it into a PC, they would have to make a record. They would have to redact the serial number, because every voter, it has its own every ballot has its own serial number, which is a unique identifier. They would have to actually redact that, and they would have to. You have the data, but you don't have it as a record. You are not required to create a new record, and that's exactly what they would be asking us to do here. Pull up, make a digital image, and then redact it and give it to them. We are not required to do that under Washington law, even if we were required to produce this record, which we are not. All that aside, again, we come back to what is Washington law? What is important to the citizens of Washington? To the citizens of Washington, the secrecy of the ballot is absolutely primary. If you do look at those out-of-state cases that plaintiffs cited, in one case in Colorado, they print copies of the ballots for people to see. They have a totally different statute. In both cases, they're talking about different statutes that are totally different from what our legislature created, what our legislature thinks is important. But here in our state, our legislature has put a premium on the privacy of the ballot, and it's part of Kathy Garber's job to make sure that when someone submits a ballot, it remains a secret ballot. That's her job. And, you know, the plaintiff is like, well, you can redact it. Well, you really can't. The legislature has also created a way for people to be involved in the voting process. Voter registration lists are public. People who submit ballots, that's public. Their precinct is public. So if you're in a smaller precinct and you're turning your ballot and the plaintiff has access to these daily tallies of who's turned in their ballot, he can look up, see what precinct you are, and if you're in a precinct, which can happen, of 8 voters and only 2 have turned in their ballots, he can pretty much figure out who's voted what when. And why is that important? It's very important. It's important for people on, I work for an elected official. I love my boss, but I don't need him to know how I vote. Everybody in this government works for an elected official. I mean, this would have a chilling effect on people. His willfulness in not following and not pursuing the appropriate law should not be something that we are penalized for. And based on that, Your Honor, based on that history, based on his desire to change the law through the courts rather than through the legislature, we really do ask at this time that his motion be denied and that we are also awarded costs in this case.
First of all, a couple of questions, Mr. Zemmel.
Yeah.
Is this really a statewide issue? Is this going on in other counties? And if so, how many counties?
Well, in terms of pending litigation, or in
In terms of the request and or litigation
the
corresponding to
requests were
this?
made to many other counties, and
What are there,
they're,
39 counties in Washington? I can't remember.
I would defer to your knowledge on that. And there is a pending.
So were there mirror requests in every other county?
Yes, yes, Your Honor, and that's in the declaration,
Okay.
and
And
the email with which the request was conveyed to all the counties is also in the declaration.
may I assume there's litigation in other counties as well?
There is in Snohomish County against Skagit and Island County. It's one case.
Out of curiosity, have any other counties produced the requested information?
Ms. Veto said we can't read the image code, and I would just like to point out that there is a specific process called ballot resolution, in which the image of the ballot is brought up on a computer screen, and election officials look at it to determine whether or not a preference was indicated on the ballot in a way that the computer program wouldn't be able to read, but that a human would be able to interpret and carry out the wishes of the voter. So it's just not truthful to say that they can't read the image code. And further, I would just like to reiterate the obligation that the counties and all agencies have to decrypt encrypted records and to convert it into a format that is readable by the public. The whole point of the Public Records Act is to make these public records available to the public, to hold agencies accountable to the people, to retain control over the procedures that the people have created. And in this context, the voter indicated his preference on a paper ballot, sent it in by mail, the county scanned it and imaged it, and that paper ballot is deposited in a container, and the image itself is maintained on a disk in code, just like every other digital file. The fact that it's ones and zeros doesn't mean anything. All digital images, when you look at it without a software program to interpret the code is ones and zeros. When you open up a computer, you don't see a picture in it. You see silicone and, circuit drives, and it contains code that is interpreted by a program that generates an image. They have the program that can interpret the code to generate the image. They can see the image, and they should produce copies of it pursuant to the Public Records Act. It's very simple. I also want to touch on the alternative means method. They say that the proper forum for Mr. White to obtain these records are through the election laws, which limit access to ballots to election contests. There are other reasons that an individual might want access to these ballots, and the purpose for requesting the record is not a reason to deny the request, and it's explicit under the Public Records Act. The Supreme Court has also held that if there's any conflict between the Public Records Act and any other statute, that the Public Records Act controls. So when an agency says, "Oh, you should have gotten this from this other process," but that process limits it to certain intent, that is necessarily in conflict with the Act and is not an exemption. I also want to highlight the quote from the Supreme Court that I quoted earlier in Lindstrom v. Ladenburg. Quote, "The fact that records are readily available from another source is not a reason to deny a record." This isn't a separate situation just because it's in an election context. The election context is actually where the Public Records Act is extremely important, because that is the fundamental instrument of our democracy, and the Public Records Act is meant to retain sovereignty to the people and maintain control over the instruments that they have created, which is...
And I would also
What's
like to-
what's the specific
the pres-
preempting statute? What's the exact? Let's get down to brass tacks. And
It's
what's that?
29A.60.110. This
Stand by.
is the only
Stand by. I'm
way.
looking at 29A.60.
Yes, this
Point-
is the only way that ballots can be accessed.
What's the 2960? 29A60.
Point 110.
110. I'm pulling it right up so I can follow along. Thank you.
And I would like to point out that everything that I said about our voting machines, I relied on our election supervisor's sworn testimony, and I really object to being called less than truthful. In 23 years of being a lawyer, no one's ever accused me of that, and I would submit
Well-
that my testimony from my client is much more convincing than counselors' off-the-cuff remarks that have no basis.